attempted murder charge.
Yes.
The crime with which you're charged, of course, as I said, is attempted murder. It's a Class B felony. It consists of certain elements. In order for you to be convicted of this crime at a trial, the state would have to prove each of those elements by evidence beyond a reasonable doubt. Now, the state would have to prove, and the elements include, that this happened on or about April 29, 2013, that it happened here in Woodbury County, Iowa, and that on or about that date, you shot Sioux City Police Officer Kevin McCormick, and that by the acts that you undertook that particular day, you expected to set in motion a force or a chain of events which would cause or result in the death of a Sioux City police officer, specifically Officer McCormick. And that when you acted as you did, you intended to cause the death of Sioux City Police Officer Kevin McCormick. Do you understand those elements?
Yes.
Knowing what you know as to what happened, do you believe you committed the crime set forth in count 1, attempted murder, Class B felony?
Yeah.
Did it happen on or about April 29, 2013 in Woodbury County, Iowa?
Yeah.
And on or about that date, did you in fact shoot Sioux City Police Officer Kevin McCormick?
Yeah.
And your actions on that particular day, did you take them expecting to set in motion a force or chain of events which would cause or result in the death of Sioux City Police Officer Kevin McCormick?
Yes.
And when you so acted, again, on that same day, did you specifically intend to cause the death of Sioux City Police Officer Kevin McCormick?
Yeah.
Okay. The court also has had a chance to review the minutes of testimony and based upon the defendant's responses to the court's questions, as well as upon review of the minutes of testimony, there's a factual basis of court so finds. Mr. Loomis, would you advise Mr. Dean what the maximum penalty is for conviction of attempted murder?
Yes, sir. Count 1, attempted murder, is the Class B felony. The defendant faces an indeterminate term of incarceration not to exceed 25 years. Pursuant to Iowa Code Section 2.12, the defendant would be required to serve 70% of that sentence before he is eligible for parole. Also, pursuant to Iowa Code Section 910.2, the defendant would be required to make restitution to the victims for his criminal activities. Those are the mandatory minimum and maximums for the charge of attempted murder Class B felony.
All right, thank you, Mr. Loomis. Mr. Dean, do you understand that those are the maximum penalties to be imposed here?
Yes.
All right. The court's been advised that restitution is not specifically set or finalized at this point in time. At the present time, there may be as much as $9,432 in restitution. Again, that's not a final number. Do you understand, Mr. Dean, that the court will order restitution and amount, perhaps determined at the time of sentencing, as a consequence of your acts?
Yes.
I accept your plea of guilty. The court has the authority to order a defendant to perform community service. I will order you to pay court costs and fees of your court-appointed attorney in this case. Do you understand that?
Yeah.
Are you a United States citizen?
Yeah.
Okay. Are you on probation or parole anywhere else at this time?
No.
There is a written plea agreement between the parties in this case, and it appears as if I have the original, and it's up here in front of me. Did you sign this document?
Yes.
All right. Did you go over it with Mr. Jones?
Yeah.
Get any questions that you had answered?
Yes.
Okay. Do you have any questions about it today? No. All right. Mr. Loomis, would you summarize the plea agreement for us at this point in time?
Yes, Your Honor. In FECR 085517, the defendant is charged with attempted murder, assault causing serious injury, assault on a peace officer, willful injury, and going on with contempt. In FECR 085517, the defendant is charged with robbery in the first degree, burglary in the first degree, 2 counts of theft in the second degree, and assault while participating in the felony. In FECR 085517, the defendant will enter a plea of guilty to the charge of attempted murder or Class B felony in count 1 of trial information. In exchange for his plea of guilty to count 1, the state will dismiss counts 2 through 5. The state will also dismiss the counts 1 1 through 5, and that be CR 085470. These charges will be dismissed after the defendant has been sentenced, unless the defendant takes any action to invalidate the plea taking or sentencing performed pursuant to this agreement. If the defendant takes such action, then the above criminal charges will not be dismissed. Sentencing on count 1, attempted murder, class B felony, enforceable felony. Pursuant to section 702.11, the defendant should be committed to the director of the Iowa Department of Adult Corrections for an indeterminate term of incarceration not to exceed 25 years. This term will not be suspended or deferred. Pursuant to Iowa Code section 902.12, the defendant shall be denied parole or work release until he has served at least 70% of the maximum term of the sentence. Minimus shall issue upon judgment is pronounced. Pursuant to Iowa Code section 9038.5, the defendant shall receive credit for the days spent in confinement and disposition of this case. The court shall order the defendant to pay court costs, including but not limited to the cost of his court-appointed attorney. Pursuant to Iowa Code section 910.2, the court shall order the defendant to make restitution to Sioux City Police Officer Kevin McCormick in an amount to be determined. In the event the defendant requests reconsideration of the sentence, files an appeal, and makes application for post-conviction relief concerning this agreement, or the plea taking or sentencing performed pursuant to this agreement, the state shall have the right to reinstate or refile the criminal charges that were pending prior to this agreement. The defendant waives any right to speedy indictment and/or statute of limitations. The concurrence of the court to this agreement is a condition of the acceptance of the plea. Should the court reject the terms set forth in this plea agreement, the defendant should be allowed to withdraw the plea of guilty, and the state shall have the right to reinstate or refile the criminal charges that were pending prior to this agreement. Further, the defendant waives any right to speedy indictment and/or statute of limitations. Additionally, Your Honor, the state would like to note that the parties have agreed that the state will not file any charges arising out of an incident that took place on April 15, 2013, here in Sioux City, Newberry County, Iowa. Those are the terms of the plea agreement.
All right, just to confirm, the incident you referenced, April 15th, is currently uncharged conduct, right?
That's correct, Your Honor.
Mr. Jones, first, is that how you understand the plea agreement?
It is, Your Honor.
And Mr. Dean, is that how you understand the plea agreement?
Yeah.
Okay. Just as a matter of clarification, Mr. Jones, I wanted to do this earlier, and I overlooked it, but your counsel of record on FECR 085597, is Mr. Pittenger counsel of record on the remaining case?
Yes.
Okay, and I did need to know that Mr. Pittenger is actually in the courtroom. Mr. Pittenger, are you aware of the terms and conditions of the plea agreement that we just described?
Yes, Your Honor.
And is it as you understand it to be related to your particular case?
Yes.
All right. And I wanted to a couple other things I want to confirm on the record as best I could, and that is that I should have asked earlier, Mr. Dean, but you understand that this is a forcible felony. The court has no authority under Iowa law to suspend your sentence or, in fact, to reconsider your sentence. Do you understand that?
Yeah.
All right. And what that essentially means as a forcible felony means once you're sentenced, you will be ordered to go to prison. I have no discretion. You understand that?
Yeah.
Okay. Now, I just want to confirm with you and with counsel that there is no representation being made by anyone in the courtroom as to what, if anything, will happen with regard to any potential federal charges. Is that true, Mr. Lewis?
It is, Your Honor.
Is that also true, Mr. Jones?
Yes.
And do you understand that, Mr. Dean?
Yeah.
Okay. Whatever they're going to do, they're going to do. We're not telling you what they're going to do. You understand that?
Yeah.
Okay. Other than what is in that written plea agreement and the additional record that we just now made with regard to the uncharged conduct and related items, has anybody made any other promises to you in case you plead guilty to this charge?
No.
Has anyone threatened, forced, or pressured you to plead guilty?
No.
your discussions with Mr. Dean in this case, do you believe he understands his rights, the nature of the charges, the consequences of his plea? Do you believe his plea will be voluntary?
I do, Your Honor. He does understand the nature of his charges. We discussed this case in great detail. And he's had access to all police reports as well as all the videotape interviews and audio interviews that were done. So I believe he fully understands this case.
All right. Before I proceed to ask the defendant for his plea, Mr. Loomis, is there anything else that I've left out or overlooked or any additional record you want to make?
No, Your Honor, thank you.
Then, Mr. Jones, I'd really ask you the same question. Is there anything else by way of record you want to make or we've left out?
No, Your Honor.
Mr. Dean, then, one last time for you, is there anything that you feel you need to know before I ask you for your plea?
No.
All right. Would you please stand then? So I can inquire regarding count one of the charges attempted burglary, class B felony in violation of Iowa Code section 707.11. How do you plead, guilty or not guilty?
Guilty.
Okay, thank you. You can be seated. The court's going to make the following findings. I find the defendant is fully competent and capable of entering an informed plea. I find his decision to plead guilty is voluntary, knowing, and not the result of force, threats, or promises, except those set forth in the written plea agreement, as well as the other representations made on the record here this afternoon. I find the defendant fully understands the charge against him. I find there to be a factual basis for his plea, and I find that he knows of the maximum punishment that could be imposed on this charge. I find that he knows of his jury rights and has voluntarily waived those rights. Therefore, I find the defendant should be adjudged guilty based upon his plea of guilty to attempted murder as set forth in count one of the trial information in FECR 085517. The court accepts the defendant's plea of guilty, and the court intends to be the sentencing court, so the court also accepts the plea agreement between the parties and agrees to be bound by the terms and conditions of the plea agreement. And now that I've accepted your plea, Mr. Dean, you have the right to make a motion in the rest of the judgment. Any challenge to your plea of guilty based upon the defects in this plea proceeding must be raised in a motion in the rest of the judgment. If you do not challenge the adequacy of this plea proceeding by filing a motion in the rest of the judgment, you'll be giving up the right to assert such a challenge on appeal. If you wish to make a motion in the rest of the judgment, you must do so not later than 5 days before the date set for pronouncing sentence, and also not later than 45 days after your plea of guilty. In other words, you must file a motion by the earlier of those 2 times. Mr. Jones can give you any further information about your right to file a motion in the rest of judgment. I'm going to order a pre-sentence investigation report and a set sentencing for August 9, 2013 at 10 a.m. here in Woodbury County Courthouse. Anything further, Mr. Lewis?
And just for clarification for purposes of the record, you took the defendant's plea. Not sure if I misunderstood, but was it for attempted murder and not attempted burglary? I'm not sure what you said, but I want to make sure that guilty plea was for the attempted murder charge.
Well, I apologize if I said something I didn't intend. Thank you, Mr. Lewis. I must have misspoke. And I need to clarify that. I apologize. I don't know where that came from, but nevertheless, Mr. Dean, I think I asked you whether you plead guilty to attempted burglary, but I cited the code section 707.11, which is attempted murder. So how do you plead to the charge of attempted murder as set forth in count one under code section 707.11?
Why didn't you give us the burglary? Discuss that?
No.
You didn't plead guilty to the burglary. I'm just clarifying the record at this point in time.
I'll be burglary, murder.
So how do you plead to attempted murder?
Yes, not burglary.
Okay. Well, I misspoke. Obviously, you're not even charged with attempted burglary in this particular case. So I appreciate you being diligent, Mr. Lewis, and bringing it to my attention to clarify that. None of us need that to be causes difficulties a little later on. So, all right. Anything else, Mr. Lewis? felons. Okay, we'll be in recess.